We have a lot of questions today, which is awesome, over 22. Just a quick recap before we get into the questions. We had over 104 live viewers today on Zoom, and many others were with us here on Facebook Live. So thanks everybody for being here. Our first question is from somebody who asks, in 2019, we added a 6-month minimum rental restriction to our rules and regulations. Is this valid for the HOA to enforce? I mean, I have to look at all of your documents, but probably not. It just depends on what your CC&Rs say. Maybe your CC&Rs have an open-ended provision in there that says that, rentals are allowed and the board can pass rules regarding, minimum time periods, but I doubt it. So, short answer would be it really needs to be in your CC&Rs in order for that to be enforceable. Maybe your CC&Rs allow you to pass rules specifically regarding minimum time period rentals, although I think that's really going to be a stretch. I doubt that's the case. But bottom line is this really needs to be in the CC&Rs, and the statute from 2016 specifically says that. Okay, next question. I submitted an architectural review form in April. I still have not had a response. What are my options? Okay, I know you were at my last presentation that I taught, and you asked a similar question too. Basically, what I would do is I would write back to the architectural committee and give them another copy of it, hopefully you have a copy of it, and demand for a response. Say that I submitted this back in April, I haven't received a response yet. I'm asking please for a response, and give them a time period. If they don't respond within that time period, you can go to the Arizona Department of Real Estate, file a complaint. You can hire a lawyer to send them a letter. You should check your documents to see if it's automatically approved if they don't respond within a certain time period. I think all of these are good options, but first make one more effort, write to them and ask them to, make a decision on it and give them a leash of 30 days so that they know, and tell them what you're going to do if they don't respond. Okay, question 3. Upon homeowner's request for an association to provide records, is a fourplex unit association required to disclose records? Can you clarify? Okay, if you are a homeowners association, like an HOA, planned community, or condominium association, you are required to provide records to your association members if they request those records. You have 10 business days to provide the records to them after they've been requested. You can charge 15 cents per page for any records that they want a copy of. There are some records that can be withheld from disclosure, but there's very few, frankly, that you can withhold. Some examples of documents that could be withheld would be like legal opinions from the association's attorney to the board. Any litigation that's pending, we wouldn't be able to give any information regarding that, any settlement discussions or meeting minutes from the executive session. On the topic of executive sessions, as a homeowner, you're not allowed to review the executive session meeting minutes, so that would be something that you can't have. But basically, there's a lot of information, like 98% of the association's books and records you are allowed to see. So if a homeowner makes that request in writing and it's not a category that can be withheld, the association needs to get those records to the owner within 10 business days. Okay, next question. Number 4, at a recent board meeting, a homeowner suggested a plan to charge owners who rent their properties $100 per month fee, based upon the belief that the owners who rent their properties don't take as good a care of their unit as an owner resident. The fee would be used to offset expenses incurred due to lack of care. Can an HOA charge a fee on this basis? So my short answer would be no. I think we talked a little bit on this in my presentation, but I think that would be discriminating against owner landlords, and I would not suggest doing that. I think it won't withstand a legal challenge. Next question, number 5, as treasurer for my board, how much should I report on at an open meeting? Okay, really good question. So I've served as treasurer of my board as well. I think you should give just a quick overview at each regular board meeting of how the association, how much money we have in our, checking account, in our savings account, in our reserve account, in any CDs, when those CDs might be expiring, and what the plan is. You should be analyzing or making statements. Like if you have money in banks, is the money spread out so that you're under the FDIC cap in every bank? I mean, you could just make a very short statement, like I've got that on my radar, making sure that we never get over the FDIC cap, where there wouldn't be insurance, FDIC insurance, if we had over the limits that's insured. You should talk about the budget for sure. Like point out what I would do typically is I would say, okay, we're a little bit over budget on this, and here's why, and we're a little bit under budget on this, and here's why, and here's our plan to, make sure that everything evens out. We have enough money. Maybe you have like litigation or something that's something you didn't plan for, and you have, you're way over budget on legal. Well, I think this case is close to settling, or will be paid when we win the case. Just try to have some thought process analysis as to, how we're going to make it till December. And do we have enough income coming in to pay our bills? Also as treasurer, you should be, giving an update on anything that may be happening that, might be a problem. Like let's say you've got 5 owners that are delinquent. And that's, making a pretty hefty dent in the amount of income that's coming into the association and how that's being handled. Well, we've turned these files over and have a lien recorded with our attorney, and the attorney is pursuing these owners for the debt, etc. And so it really should just be 5 minutes, I would say at the most. And you should just give an overview. This is how much money we have. Here's where the money is. We've got a CD that's expiring next week. Here's the plan on what we're going to do with that. Here's our budget. Here's where we're a little over. Here's where we're a little under. We're doing fine. And if there's a problem like delinquencies, talk a little bit about what you're doing. So it's pretty basic, just a quick financial overview. What you don't want to do is do like 30 minutes, deep dive, too much information, because that's too much. Your job as a treasurer is to give a short summary of what's going on. The board packet should have all the backup information, including the year-to-date budget, the bank statements, everything, so that if a board member wants to do a deep dive, they certainly can, or if they want to meet with you individually to ask questions, they certainly can. Okay, next question, number 6. Can the manager require a copy of the insurance policy on the unit if the contract only recommends insurance? And so I'm guessing that you're trying to get a unit owner to provide like contents insurance proof, or maybe you even have additional insurance requirements. Unless the CC&Rs mandate that an owner has to provide you with that information, the manager can't require it. If it was in the CC&Rs that all owners must provide this to the board, then yes, you can require it. But absent that, you cannot. Question 7, how can we legally distinguish between tenants and roommates? One homeowner has 6 roommates in his home. That's a really good question. So, in theory, roommates pay rent. So I would send a letter to the owner, and they may also be over the occupancy limitations that may be imposed by your city, town, or county. So you might want to check into that too. But I would send a letter, have the board send a letter asking for more information about, who's living in the property. Is there like a landlord-tenant relationship? And if so, you can ask for the names. Like we said, just go through the categories of information, the names of the adults, their vehicle license plate numbers and vehicle description. All of that information you can ask for from them. Okay, question number 8. Can you define tenant versus occupant? This is an interesting idea in terms of fees where you use the term tenant. Okay, so a tenant is going to be typically somebody who there's an exchange of money for them to live in the property. An occupant could be like a family member or a friend who's just hanging out there, staying there for a couple of weeks. Maybe, they're being allowed to stay there for free. Again, in this situation, you just need to reach out to the owner and ask for more information. Is this a tenant? And if so, you're required to provide us with this information. Now, if it's just a friend that's there, the owner can decline and say, listen, this is not a landlord tenant type situation here it's a friend that I'm allowing to stay here. And under the CC&Rs, I have a right to delegate the use of my home to a friend if I want to. Next question, number 9, who retains the $25 registration fee, the association or the property management company, if they are managing their registration process and monitoring it? Well, the association can charge the fee, the $25 fee and the $15 late fee if the tenant information is provided in 15 days. Now, who gets that money is really going to depend on what the management contract between the association and the management company says. And so, the law says that the association can charge it. So if the association wants to take the $25, you certainly have the right to do that under the law. But recognize that the management company may have negotiated a contract that says that they get that money. So you have to look at that contract to determine the answer to that question. Next question, number 10, I'm an interested homeowner. Our HOA board just required that we sign up for online parking permits. If a guest is to stay past 10 p.m., we must pay a fee of $5 per each vehicle. For a party of 10, $50. Many owners are upset and think that we have to pay for a guest to stay past 10 p.m., but that we are required to create an account online with the business and provide vehicle and contact information for guests. As part of the agreement, we have to allow data collection to be multiple companies. Are there any laws that would prevent this? This is really weird. I've never heard of anything like this. At first glance, I think it's possibly not enforceable. It would need to be in the CC&Rs for sure if you were going to be charging for something like this. But again, this is just kind of out there. I don't think this is something that I would ever advise a client to do. And so you may want to it sounds like you're a homeowner, interested homeowner. You may want to raise this issue with the board or you may need to get your own attorney to send them a letter on this because it does not appear to be enforceable. But I don't have all the facts on it. So you'd have to, I'd have to see all the paperwork to definitively say, yeah, I don't think this can be done. But at first glance, this doesn't look good. Okay, next question, number 11. Which state law is it that the landlord is possibly responsible for criminal activity? Okay, so it's ARS 33-1806.01. I think it is, or L, provides that an owner of a rental property shall abate criminal activity as authorized in section 12-991. And so it's really specific, in that they have to abate criminal activity. So basically what that means is, they're going to be held responsible if there's criminal activity going on in their property and they don't do anything to abate that criminal activity. Now, they're not going to be charged with the criminal activity that the tenant was doing, but they are going to be charged potentially for not abating that criminal activity. Okay, next question. HOA board member says he's not renting, but his sister lives at the property. No rentals are allowed. The assessor's website doesn't show it's a rental. Is this legal? It probably is. Now, you'd have to find out, is the sister paying rent, or is she just truly living there for free? These are always tough calls whenever people have friends coming in to stay and, you don't have any information that shows otherwise. But let's say the sister goes to the pool some Saturday and she talks to another owner there and says, oh, I'm so lucky. My brother's letting me live here and I only have to pay $500 a month. Well, then that sounds like a rental relationship to me. And then the owner would have to rent. But again, it's hard to prove those. Okay, next question, number 13. As a board, how do we know if the landlords have insurance required by the city and or county? Really great question. It depends on how the cities and counties are going to write up, their ordinances and requirements pursuant to this new law that's going into effect on the 24th. So what I would suggest is that you reach out to the city, town, or county that you live in after this weekend and find out, are you going to require this proof of insurance pursuant to this new law, and how would we go about getting that information? Now, remember, if the property is listed in an online portal like VRBO or some other online rental services, they probably get insurance through that. And you likely would be able to write a letter asking for a copy of that insurance as a board. Okay, next question. Is month-to-month rental considered short-term? So I'm guessing typically what happens is, so short answer, probably yes, it is. Because you're just doing like a 30 day rental, and it just kind of keeps getting renewed. But sometimes, it's been like a year lease, let's say, and then the lease expires, and then you're just going on month to month. I would be cautious, and I wouldn't be in favor of you saying to somebody, like, let's say you have a minimum year rental period, and somebody, is extending their lease by just staying month to month. I don't think you can say that they're short-term, rental in violation of your minimum 30-day rental period or something like that. So you want to just look at the facts on that on each matter and determine, whether or not this is a short-term rental or not. Question 15. We successfully passed a 30-day minimum rental in our revised CC&Rs. However, we still have owners who violate the rule. What are our enforcement options? So we talked about that a little bit here today, right? So enforcement options would be, number one, have the association send a letter to the owner regarding the violation. Number two, fine the owner after giving notice and an opportunity to be heard. Hire an attorney to send a letter or do a phone call to the owner, about the violation, filing a lawsuit against the owner in Superior Court, going to the Department of Real Estate, Arizona Department of Real Estate, and filing an administrative complaint to be heard by an administrative law judge against the owner. Those are all different ways to rectify this problem. Obviously, like I said earlier in this presentation, if you want to make it hurt for the landlord, make it hurt in their pocketbook. Big fines, attorney's fees, and potentially having to pursue a lawsuit. Okay, next question. Let's see, number 16. Can an HOA change CC&Rs to prevent any new homeowners from renting their units? So I think kind of what you're thinking on this is, okay, we're going to grandfather everybody who lives in the association, and we're going to pass an amendment that says any new owner who purchases after, this date certain, probably it's going to be the date that the new CC&Rs get recorded, can no longer rent. I mean, it's possible that that's something that you definitely can do. We have to look at whether you're a condominium or a planned community, but that is kind of a creative way to withstand any legal challenges, because whoever's buying, they know what they're getting into. They see right there, and they get the CC&Rs disclosed to them as part of the disclosure statement, hey, no rentals. You may get pushback from small owners, though, because they want to have options when they sell their property. And if they think that they can only sell to, owners who are going to be owner occupied, it could limit their pool of people that would be willing to buy the house. But just a couple thoughts. I think that's helpful to get you pointed in the right direction. Okay, 9 more questions. Number 17, how does the recent Arizona Supreme Court ruling impact CC&R amendments? Really good question. So there's a recent case that was decided by the Arizona Supreme Court that seems to limit the ability of associations to pass amendments that aren't foreseeable to the membership or the owners. I really think I've thought a lot about this. And if you look at, what the 2016 legislature did, they basically, through statutory changes, they told us if you want to implement minimum or you want to implement rental restrictions, you have to make an amendment to your CC&Rs. And so I think the way to argue this, if you want to implement, changes to somehow regulate rentals or eliminate rentals, you're going to want to rely on that statute and say, this is what the legislature told us to do. And I don't have an answer because there hasn't been a case yet where this has actually been decided by an appellate court. But my inclination is, and I'm pretty conservative on these things, is that this would withstand a legal challenge if we could argue that, hey, the legislature told us this is what we need to do if we want to implement this. And that being said, too, prior to 2016, we didn't really need this. It wasn't foreseeable that this could happen because all of this was handled, the rental part of it was handled through ordinances and the cities. So we're still doing rental restriction amendments. We're helping clients with rental restriction amendments and rental prohibition in associations. We do mention the risk with the new lawsuit that there could be a challenge to it, but we're writing it in such a way that we think will withstand any challenge that could be made. Okay, next question. Can an HOA restrict commercial vehicles? Yes, it would need to be in your CC&Rs. In order to do that, there's a couple little exceptions for emergency vehicles under state law. So you would want to become familiar with that. If it's an emergency responder that needs their vehicle at home, they would probably be a loophole or exclusion to any amendment that you would do on that. But generally speaking, yes, you can. Okay, next question, number 19. We have several rentals that are not part of our HOA, but within our subdivision from a new builder. We allow use of our common areas, such as the pool, with a small fee paid to us. Can we ask that they follow our rules and regulations? For example, pet must be under 40 pounds. If your rules say that, and you're saying they're not part of your HOA, but you're allowing them to use the pool with a small fee. Well, if you're allowing them to use your pool, then of course you can tell them that we have rules at the pool and you can't do this. So I think that's enforceable. Question 20, in planning limits on the total number of rental units in a community, does that require an amendment to the CC&Rs or can it be changed by a majority vote of the board? So this association wants to put a limit on how many rentals there can be in an association, like only 20% of the units can be rented or something like that. That definitely would need to be put in the CC&Rs as a CC&R amendment, and that's not something that could be changed just by a majority of the board. Okay, next question, question 21. And let's see, what if the HOA or condo community is allowing some owners to say they are just friends and relatives staying at their condo, and that the community should not be concerned when they see people coming and going? Our rules require a 30-day minimum rental, but may not be enforced on some units because they say that they're friends. We've talked about this a couple of times now in the questions. These are hard to prove. I would ask the owner to document who's coming in and out so that, the association is aware of, who's coming into the property and, who's authorized to be there and who's not, if this is a very frequent thing. I would gently remind them of whatever rental restriction policies you may have in place. But unless you have any evidence that they are actually exchanging money, it's going to be hard to prove that they're using it as a short-term rental. Okay, next question. Is there a definition for a short-term rental? Yes. If you go to, there was a statute recently, Senate Bill 1168, that talks about vacation rentals and short-term rentals. You can look that up online. Just go to the Arizona Legislature's webpage and Google that, Arizona Legislature, type in Senate Bill 1168 in the search engine when you get to that page. And, there's a section that gives a definition of a vacation rental or a short-term rental. Just generally speaking, it means any individually or collectively owned single family or 1 to 4 family house or dwelling unit or any unit or group of units or a condominium or cooperative that is also a transient public lodging establishment or owner occupied residential home offered for transient use if the accommodations are not classified for property taxation under section 42-120-01. This does not include a unit that is used for any non-residential use, including retail, restaurant, banquet space, event center, and other similar use. Okay, we're getting down to the end. We're down to our last 5 questions. This question is, a couple bought a home in our townhome community. Our understanding is when they complete renovating it, they plan to use it as an Airbnb. Our CC&Rs prohibit any resident from running a business of any type within their home. They said that they were going to put their property into an LLC. They will not be living in the home. Would that be considered running a business from that home? Interestingly, no, it's not. The business restrictions in your CC&Rs, unfortunately, do not extend over to rentals and rental properties. So if you want to restrict short-term rentals in your community to stop something like this from happening, you would need to do an amendment to your CC&Rs. Okay, last 4 questions. When Arizona Legislature passes new laws, do they print amendments to the existing laws? Yes, they do. So starting after the 24th, you can go to the Arizona Legislature's webpage, and the new changes should be implemented when you look at the listing of the codified new laws. Next question, 25. Our legal counsel has advised us in the context of the Arizona Supreme decision of Callaway versus Calabria Ranch, which is the case we've been talking about here today, that put some limitations on amending CC&Rs, that our lawyer has told us that we halt our efforts to pursue amendments to our CC&Rs to restrict vacation and short-term rentals, pending further clarification by the legislature or the courts. In that light, do you recommend that we at least implement HOA monitoring and management of short-term rentals per the recent legislation? We currently have no established HOA practices to track or manage vacation or short-term rentals by our community management company. Okay, so as I stated previously, we are not telling clients to stop, passing amendments to CC&Rs, based upon the Callaway case. What we are telling them is be cautious. Let's think it through. Let's have a strategy about how we structure the amendments. And so I'm going to respectfully disagree with what your legal counsel is saying. Do I recommend that you start monitoring, how many you have in your community? Of course, you should be keeping an owner list, and under the law, you're required to. And if you want to make a notation that, hey, this is a rental property and this is not a rental property, you certainly have the right to do that. It's useful information for when you do ultimately decide to do an amendment. You'll need to know how many properties you have in your community that are rentals versus not rentals. And something to think about is the longer you wait, the harder it's going to be for you to get those votes to implement that short-term rental amendment. So really think that through, because it could take years for the legislature, for the court system to have another case wipe and have a decision, made to better clarify that Callaway case. Okay, next question, number 26. The new law regarding political and first responder signs and flags seems to allow on the owner's property. In that we have a patio home condominium community, and the association apparently owns everything, such as the front lawns, but inside the unit walls, can the association still restrict display other than, say, inside the windows of the unit? Okay, so the first responder flags or the other United States flag, the first responder flag is just kind of like an extension of the existing flag law, that says that owners should be allowed to fly American flag, Indian Nations flag, or armed services flags. And now it's extended to first responder flags. So if you live in a condo, where can you fly them? You can put them from the inside of your window. Would be one way. You could hang from your limited common elements. Typically it is, okay. What you can't do is put it on the common areas. Okay, next question. What if the renter was renting before the HOA changed the CC&Rs to require a minimum of 30 days rental? Can they be grandfathered in? Okay, that's a really good question. I'd have to know more. So if the renter was already renting before the HOA changed, I don't know what anybody was renting previously. So maybe they come every March to Arizona and rent your condo. And it depends on how the amendment was structured. Does the amendment say that, effective this date, it has to be a minimum 30-day rentals? Did it grandfather existing owners? I don't know that information, but it sounds to me like, any new rentals that are amended, that are created after the amendment, would have to be a minimum 30-day rental. Now, if the owner is using like an online platform and they booked out, months in advance, the association potentially could have, a legal problem because now that owner is, going to be breaking contracts. So talk to your attorney about this and come up with a plan that's going to be a win-win for everybody. You may have to allow the owner, through their commitments, let them do less than 30 days so that you don't get sued by the owner. But then any new ones after those written commitments, those would not be allowed. Okay, that's it. Got through all our questions, 27 questions. A few things to mention as we look forward to a cooler October in Arizona. We have a lot of learning opportunities coming up. And so we want to make sure that you're aware of them. First things first, we had 104 live viewers here today on Zoom, and many others joined us on Facebook Live. So thanks so much for being here today and caring about your communities and wanting to learn more about this important topic. This week, Mulcahy Law Firm is going to be sending a daily email introducing and explaining the 5 new laws that are going to be impacting HOAs and condos starting September 24th. We hope that you're going to follow along with us. We sent the first one yesterday, and we're going to send one today and throughout the week. So keep your eyes open for today's new law, which is going to be sent out this afternoon. Next, our virtual First Friday free call-in is going to be Friday, October 7th at 9 a.m. And this is an opportunity for anybody to join us on Zoom or Facebook Live and ask one question for free. It's just a great opportunity for board members or homeowners to reach out and ask a question about HOA or condo law that you don't know the answer to and to try to stump me. And so we're going to be doing that again. It's always the first Friday of every month, and you can join us on Zoom or Facebook Live. Also, don't forget we have our next class for our virtual HOA Condo Academy, and that is going to be on Tuesday, October 18th at 11 a.m. Class number 10 of our series for 2022. And this topic is going to be on a topic that I think applies to every association in the Valley. We're going to talk about how to enforce your CC&Rs. So how do we get owners to comply with the provisions in your CC&Rs and your rules? And what legal rights do we have, and how can we pursue these violations to make them go away? And then next, we're going to talk about how do we collect delinquent assessments from owners who aren't paying. And that's a topic that's becoming more and more relevant because we're seeing a huge uptick in the number of delinquencies in associations. So make sure you join us on October 18th for our 10th class in the virtual HOA Condo Academy. Finally, don't forget to register. We're teaching a class virtually for the Scottsdale Neighborhood College on October 20th at 10 a.m. for 2 hours. And I'm going to be discussing hot topics for associations, one of the most pressing hot topics right now in Arizona and how associations can effectively navigate them. And then also we're going to be talking about how to amend CC&Rs for your association. So we have lots of free education opportunities coming up for you. They're all virtual, which we're finding from, feedback that we're receiving that people really enjoy the virtual learning. It gives them flexibility. If you can't be here live with us today, just we have all of our classes that we teach virtually. You can go back and listen to them on our website. Just go to mulcahylawfirm.com and go to our videos, our seminars tab. And you'll see upcoming classes listed on our seminars tab, and then you'll see the classes that we've already taught. The video replays can be, one click away from hearing that class again. So just in conclusion, I want to wish everybody a happy fall first. And also I want to thank our really wonderful partners, all the different cities, towns, municipalities that are joining with us to provide this free education to homeowners, managers, and board members. So special shout out to the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for having the vision to put these classes together to provide this free information to people who want to make their communities better. So have a great rest of the month, everybody. And I look forward to seeing you again in October.